Good afternoon, everyone.
Hello, Judge.
Good afternoon, Your Honor.
Please excuse the strange background. I'm working from home today. So you have a bird's eye view of my basement office. I think we've got counsel from both sides here. I see Mr. Raley. I see Mr. Is it Tatey?
Toddy, Your Honor.
Toddy. See Mr. Toddy. Are we waiting for anyone else?
No, Your Honor, we are not.
All right. So we've got plaintiff's second motion to compel and motion for reconsideration. And as I read the briefs, I think it's basically all on the same subject, that plaintiff thinks there are some documents that are being withheld and defendants don't think there are any documents that are being withheld. So let's see if we can walk through it and get to the bottom of it so that we can move this issue along, because it sounds like it's repeating. There's been a previous order entered, but that did not apparently resolve the issue. So Mr. Toddy, tell me, let's go category by category. Let's tell me what categories of documents you believe are still being withheld by the defendants.
Okay, thank you, Your Honor. So we'll start with the motion for reconsideration. And so there's four categories in that motion for reconsideration. And there's a due to, due from ledger. That's the first category. There's reports that are generated by an entity called Radiation Business Solutions that performs billing services for CurePoint. There is, so that's the second category. Third category.
Tell me that second category again.
Yeah, it's reports that are generated by a company that does the billing services for CurePoint. Radiation Business Solutions is the name of that entity.
Okay.
They generate monthly reports. We've received some, but not all of those reports. The third category is documents relating to loans that were made or arranged by a bank called First Liberty Capital. And the loans are made to, the loans at issue are made to either CurePoint or an entity called CurePoint Holdings, LLC. Those loan documents, or at least some of those loan documents, have been produced before, but they are redacted. We contend that we are entitled to those loan documents without redactions. There's a protective order in the case, so there's no reason to be making redactions to these loan documents. And then the fourth category is all documents relating to capital contributions to defendant physician financial partners, or we often refer to it as PFP. So of those four categories, I'll address each briefly, and I think it might be easiest to take them a little out of order here. With regard to category number 2, the RBS reports, Radiation Business Solutions reports. Defendants have produced some of those reports. They produced them after we filed our motion, by the way, on the day that they responded to the motion. But that production only goes through October of 2019. even though the production was made on February 14th, 2020. Obviously, defendants are continuing to withhold these reports for whatever reason. Dr. McCord is still an owner of PFP, which is the 95% majority owner of CurePoint. It is undisputed. In fact, this court has already held that those documents are relevant. So Dr. McCord is entitled to them. Why defendants aren't producing all of the reports, we don't know, but for whatever reason, they're sitting on reports. We'll go to the third category here.
All right, let's go category by category, so
Sure.
I can hear the back and forth as to each one. So, Mr. Raley, tell me about these RBS reports.
Your Honor, if I could share is it possible to share screen? I think you may have disabled it.
All right, you should be able to share it now.
Okay. Okay, can you see that, Your Honor?
I can.
Okay, and we'll go in the order as presented and as requested by Your Honor. Specifically with regard to the RBS reports, this is I've gone back through and documented everything that we have done so that Your Honor can have a clear picture on what the production obligations were and what the defendants have done in this case. Back in November of 2019, the defendants produced these RBS reports through the middle of 2018 and a little bit into the fall of 2018.
Right, so he's saying here that he's got the reports through October of 19.
Correct.
But nothing since then. We're now in 2021. So tell me about stuff after October 19.
Okay, and that's exactly right, Your Honor. He has everything through October of 2019. October 2019 was the date that the plaintiff filed an amended complaint. So up until September, up here when we first provided the RBS documents, up until that point, the allegations in the case extended through February of 2018, which is when the case was initially filed by the plaintiff. And the allegations were that there was wrongdoing, there was mishandling of funds, there were questions about the way the business had been run related to events that occurred prior to February 2018. So until the complaint was amended, it was our position, and in fact, I think it implicitly was the plaintiff's position because they ultimately filed an amended complaint. It was our position that we were producing documents up through the time of the complaint, which reflected the specific allegations in the complaint or related to them. Now, when we filed our response to the motion to compel in September of 2019, we raised this exact issue. We said the complaint was filed in February 2018, Your Honor. It relates to events that occurred up until February 2018. So we have produced all the responsive RBS records. The plaintiff then turned around a month later and filed an amended complaint. So the plaintiff, I think, realized we're limited. So they filed an amended complaint in October of 2019 saying that we believe, they didn't really specify, but they said we believe there are ongoing violations up until the time that we filed the complaint. So in response to that, because they have now made allegations up through October of 2019, in response, as I think Mr. Toddy acknowledged, we supplemented our RBS production in February of 2020 and provided all the records up through October of 2019, which is the date of the operative pleadings. So I agree with Mr. Toddy that there's not a dispute that the records up until the date of the amended complaint, which is what the claims relate to in this case, have all been produced. And that's what was before Judge Bonner. That's why she denied the motion, because we provided those records. Now, the question, what Mr. Toddy is alluding to with regard to seeking of records since that time period. As you pointed out, Your Honor, we're now in 2021, and more time has passed between October of 2019. What Mr. Toddy is alluding to with regard to a prior ruling from the court was a motion that was brought back in 2018 under the member inspection statute. And I'm sure the court is familiar, may have even had cases on their own that have been filed in front of you seeking records under the member in 1411-313, the member inspection statute in Georgia, which entitles members of limited liability companies to certain rights and ability to see records of the limited liability company. Judge Bonner took that issue up back in August of 2018 at the same time that she was addressing a motion to dismiss and a couple of other issues that had sort of stacked up early in the case. What Judge Bonner said at that time was, yes, under 1411-313, Dr. McCord he has an ownership interest in Physician Financial Partners, which is the 100% owner of CurePoint. CurePoint is not PFP's only asset, but it is its most substantial asset. But in any event, at that time in August of 2018, Judge Bonner said, under 1411-313, you need to provide Dr. McCord with the financial records related to CurePoint. And that was the order. Now, what the plaintiff has done throughout this case, and it's good that we're getting this issue in front of Your Honor finally, what the plaintiff has done throughout this case is to say, because Judge Bonner said in August of 2018, under 1411-313, that Dr. McCord is an owner and is entitled to financial records of CurePoint, that we are now entitled through the discovery mechanism to, quote, all financial records of CurePoint. And that is the wires being crossed, the apples versus oranges comparison that I think has caused some of the confusion or some of the dispute here, because it has been the defendant's position all along. We will provide you with whatever financial records are pertinent to the claims in the case through the discovery process. We provided back in the fall of 2018 all of the CurePoint records that the judge ordered us to provide at that time under the member inspection statute. But those are two separate paths. And I think what and again, consistent with what Mr. Toddy just said, the judge said that he was an owner. He's actually not an owner of CurePoint. He's an owner of PFP that owns CurePoint. So he's not a direct owner of the CurePoint entity. But the plaintiff has taken the position that because of that, they are entitled to, quote, all financial documents, unlimited in time, literally up until today. I mean, that's the position that has been taken in the case. And all we have said all along is that's not what Judge Bonner's order said. Judge Bonner's order was taking up a specific motion in August of 2018. And there is a process under 1411-313. There's a process for Dr. McCord if under that statute he believes today that he's entitled to more records of CurePoint, then that statute lays out its own specific process. He sends a letter to the company. He says, here's what I want. We either say fine or we object to it. If we can't resolve it, then we bring it in front of the court by way of a motion. But the standard for what he's entitled to as an LLC member is different than the standard of what he's entitled to as a party in this case.
Let me stop you there, because you keep referring back to Judge Bonner's 2018 order, but I've read her November 2019 order that specifically says because of the amended complaint, they're entitled to documents that are relevant to the financial position of the defendants from various parties up to and including the present based on the allegations in the amended complaint. So whether or not he has a claim as a member under a statute, he's entitled to broad discovery on anything that might lead, that's reasonably calculated to lead to admissible evidence through the Civil Practice Act. Would you agree with that?
I would, Your Honor, and I'm glad you brought that point up, because in Judge Bonner's November 19 order, if you look, let me see, I can find it here. I think I pulled up part of this. Yeah, here it is. In her November 19 order, she, as the court will recall, she denied the motion to compel. What was at issue there were a couple of motions to quash. We had filed motions to quash certain bank records of CurePoint that the plaintiff was seeking. And one of the reasons, again, that we had sought to quash those was the same argument that I made for the court just a moment ago, and that was, at the time that we filed our response, the operative pleading was through February of 2018. Now, the judge noted that after we filed our response, the plaintiff amended to make allegations through October of 2019. And what the court said there, notably, the amended complaint raises additional claims, allegations regarding defendant's conduct after this action was initiated. And so in looking, so the judge granted that motion, entitling them to the updated bank records based upon the amended complaint in October of 2019, which raised allegations in that October 2019 complaint, Judge. And I believe Judge Bonner quoted this in her order. They said to present. So to present at the time that we're filing this amended complaint. And so the judge noted that and said they're entitled, because of these new allegations that they've raised in the October 2019 filing, they're entitled to bank records up through this point, up through the present, which at the time was November of October, November of 2019. So in reviewing the judge's November 19 order, I think that is consistent with what we are saying, that they're entitled to records up through that time period, up through October of 2019 when it was filed.
But the amended complaint says it's continuing through the present. And don't you have a duty under Civil Practice Act to supplement?
You do, Judge, but I don't read the amended complaint to state a continuing tort, if it were, or it's not. Well, some of these are torts: breach of fiduciary duty, conversion, et cetera. Some of the claims in here.
Let me point you to paragraph 43. Okay. As a result of the ongoing conversion of funds. I mean, I can just turn to it and, at a random, the voidable transfers, the transfers are continuing and ongoing. That's paragraph 68. A fair reading of this amended complaint is that this is ongoing conduct. I think we've already got a ruling of the court that it's relevant and discoverable. So you have a duty to supplement, and you're going to have to supplement.
Okay.
All right. So I think that should take care of number two. How long is it going to take you to supplement?
Judge, we can have those within 2 weeks.
All right. So we've taken care of number two. All right, Mr. Toddy, let's go to the next one on your list.
Okay.
And maybe with some of these, we may be able to go through some of the other ones faster, but we'll see.
I believe we will be able to, Your Honor. So let's address some of the smaller ones here real quick. The category 3 of our motion for reconsideration is all documents relating to loans made by or arranged by First Liberty Capital to either CurePoint or CurePoint Holdings without redactions. The reason why we should not have to be satisfied by these redacted loan documents is that there is a protective order in the case. Defendants clearly know how to use that because they mark nearly everything they produce with any financial information at all on it confidential. If we dispute confidentiality designations, we can address that with court or with opposing counsel and then with the court if necessary. But Dr. McCord is entitled to unredacted loan documents. What's happening here is defendants are redacting the names of the lenders from those loan documents. First Liberty Capital, at least as with regard to some of these loans, it's not entirely clear, but at least with regard to some of these loans, First Liberty Capital is actually appears to be the middleman between CurePoint or CurePoint Holdings and some unnamed, redacted third-party borrower that First Liberty is arranging. In this case, as you know, Your Honor, we are alleging that there are voidable transfers being made currently. And defendants have asserted, among other defenses, that they made loans to CurePoint and therefore are entitled to receive payments back. Well, the identity of these purported third-party lenders are relevant to that. We shouldn't have to just take defendants at their word that these third-party borrowers have nothing to do with any of the defendants in this case or any of the entities that they own or control. There's a protective order in the case. If they want to keep confidential the names of those third-party lenders, then they can produce them subject to that protective order. We're entitled to know who these lenders are and have unredacted copies of those loan documents.
All right, Mr. Raley, tell me why these names have to be redacted.
First off, Judge, what I would point out is that this is a motion for reconsideration, I suppose, of Judge Bonner's ruling. This issue was squarely before Judge Bonner. She understood, because it was well briefed in what we submitted to her, that what we had provided was the entire notes with simply the individual names of these sort of indirect lenders. And I think Mr. Toddy described it fairly well. The First Liberty sort of acts as a middleman. They arrange for a loan, and then they have a series of outside individuals. Sometimes they make the loan themselves. They have a series of outside individuals who they will go out to and make an offer and say, do you want to provide the loan? Here are the terms. And so in this instance, there were some of the loans were funded by those individuals. Now, the reason, Judge, that there's an issue, the reason that we had a protective order in the first place, if I can share the screen real quickly, Judge. This is not your garden variety partnership dispute, and we haven't gone into some of the facts. Although the court's read the briefs, then you get a feeling for what some of the underlying facts are in the case. You know, we're in a situation where the plaintiff, despite his membership interest in the parent company, is in direct competition. As a cancer provider. The allegations in this case, and they'll be determined as we get down the road, is that plaintiff, his family, which includes his father and brother, initially withheld revenues of CurePoint for 6 months. They shut down the cancer treatment facility. They subsequently tried to have CurePoint placed in receivership. So plaintiff and his family and their entities have been actively working to cause, I wouldn't say it's harm necessarily, but it is to leverage a purchasing position. They want to acquire CurePoint, and they've been taking steps to make that happen. Now, specifically, what happened, and Your Honor we may have alluded to this earlier, or you may have picked up on it. There are probably 6 cases going on right now as between these groups, the McCord group and then the CurePoint / Philip Miles group. They're mostly all in Fulton County, but there are a lot of them going on. One of the issues we had in a case that Judge Ellerby is handling is that there were documents early on that were used by the plaintiff, in this case, his brother. Basically, if there was a name of somebody that was doing business with CurePoint, that person would get a phone call, that person would get emails, that person would get subpoenas, And ultimately what we had to do here was to put a protective order in place. And in this particular instance, to get it narrower to the First Liberty instance, we worked with First Liberty and their counsel. They were insistent that the names of their clientele, basically, that they arranged the loans through, were confidential to them and should not be disclosed. And so we worked with them, and we went back to Mr. Toddy and to Mr. Barton and said, look, we'll give you the loans, we'll give you affidavits from First Liberty to say that these individuals have nothing to do with Mr. Miles. We'll provide you whatever you want to, but the names, we're going to submit the loan documents to you with those names, with the individual names redacted. You can see the terms of the loan, the amount of the loan, see everything you want to see, when the loan was taken out. You can see all that information, but we're going to redact those. And subsequently, the plaintiff had an opportunity that they've deposed, my client's rep. They've deposed individuals in this case. They've deposed First Liberty and asked all the questions that they wanted to ask about these loans. And I give you that background, Judge, to say all of that was in front of Judge Bonner. And so when the plaintiffs complained the first time through about this and brought this up in the initial motion to compel, Judge Bonner's ruling was, we told them exactly what we had provided with those, nothing redacted except the individual names. And Judge Bonner denied the motion, said they've provided what they need to provide. And so that's the basis for the redaction of those names, Judge. And they've done a lot of discovery on those particular loans. It's simply a series of, I want to say four loans that took place. And we would submit there's no reason to revisit Judge Bonner's ruling on that topic.
Your Honor, if I may.
Yeah, I will say this first. You're reading some things into Judge Bonner's order that I don't see in Judge Bonner's order. Judge Bonner's order just talks about the category of documents, loans made from First Liberty Capital to Cure Point, and that there was a representation that all documents responsive to the discovery requests were produced. This to me seems to be a separate issue. You did produce documents that were responsive, but he's now coming back and saying it's incomplete. I don't see anything in this order to suggest that this specific issue was dealt with before. So I don't think that, I don't think that this has already been decided, at least from my standpoint. I don't see anything to indicate that this has already been decided. The question is ultimately, in the interest of discovery and justice and trying to make sure everybody is protected and gets what they need to prosecute their claims, what do we need to do to resolve this particular issue in fairness? So is the issue, Mr. Raley, that if plaintiff has these names, that they're going to go out and start soliciting or start contacting these folks to try and get business?
No, Your Honor. No, I don't.
So what's the danger? I'm not clear on what the danger is of plaintiff and or plaintiff's counsel having the names.
What has happened before, Your Honor? Yeah, it's not for business purposes. It is that every time a name has popped up, such as this, the result has been phone calls, emails, subpoenas, and not simply, in an effort to intimidate those third parties from doing business with CurePoint. So these are folks that have lent money to CurePoint. There's some suggestion in one of the briefs that money was being lent the other way or something. I'm not sure what that is about. This was simply a third party that provided funds at a time when CurePoint didn't have any money because the McCords were withholding their money. So they're trying to stay afloat. And yes, the concern, and I think it was the concern in Judge Ellerby's case as well, the concern is that you provide this information and then it is abused by the McCord side in an effort to convince those third parties that they now have learned of not to do business with CurePoint. That's
so let me just be clear as to what you're alleging is happening on the plaintiff's side. Is the coercion and the intimidation the discovery process, or is it something other than the discovery process? Because I can deal with the discovery process if there's overbroad and burdensome discovery not related to the claims in the lawsuit. We can deal with we've got the mechanism in place to deal with that. Is there something other than that you're alleging?
Judge, it's simply the use of the information that they're using. They have in the past used information obtained from discovery as a weapon to harass third parties that are doing business.
Right, and you say a weapon to harass.
Yes.
Okay, if there is somebody out there being harassed and has been harassed in the past, I assume there's been a motion to quash filed and a motion to quash has been granted, and there's some evidence in the record to sustain that. Otherwise, what I'm hearing is your argument that it's harassing, but no determination that anything by the court at any point in time that anything harassing has actually been done.
In this case, correct, Your Honor. That issue has not come up, although, again, it was in Judge Ellerby's case where the motions were filed. But here, we haven't had the issue with regard to the third parties, really, with the exception of these particular loans from First Liberty.
All right, and are we dealing with the same, when you talk about this harassing conduct, are we dealing with the same counsel? Are we dealing with Mr. Toddy?
We are
cases?
Yeah, they are representing Dr. McCord in the other case. The conduct was Dr. McCord's brother, Michael, in the other case. I will say, Judge, with regard to the one point I would make with regard to this case, just so the court doesn't think I'm seeing ghosts at every turn. In this particular case, there were documents from a deposition of a doctor that's in the middle of this, down in Middle Georgia, Trip Simpson. His deposition was taken. There were documents from that deposition and testimony from that deposition that were then used by Dr. McCord, the plaintiff in this case, brother. He actually reached out directly to one of my clients in this case, Daniel Dooley, using information from that deposition, including documents, again, to try to basically get Mr. Dooley to flip sides or something in that regard. Now, Mr. Dooley, he did turn around and provide those records back to us, immediately notified me as his counsel as to what was going on. But that's, again, it's consistent with what happened in the other case, that records were taken from this case, obtained in discovery and then used, to try to convince people to take certain actions or not to do business with CurePoint.
All right, so let me ask you this question, because I know there's a protective order in the case. If let's say hypothetically, excuse me, would the protective order entered in this case govern such a circumstance that you're talking about? In other words, would that type of conduct violate the protective order in this case?
Well, the type of contact with Dr. Simpson, Your Honor?
With the brother going and contacting someone else to the extent that they found it.
And that's why, yes. What Mr. Toddy has sort of complained about is us marking documents confidential, but if we mark the documents confidential, they are not to be shared outside this case. So if we mark the document confidential, then Dr. McCord is not to share the records with his brother. And presumably, if his brother were to then start harassing somebody based upon records obtained in this case, it would reflect that Dr. McCord had violated the order. So in that instance, Your Honor, again, if he adheres to the order in this case, than he does. If his brother ends up, on the phone as he has done in the past, then that would reflect a violation of the protective order in this case.
All right, so I think this is discoverable information, and I've recognized your concerns and your client's concerns about this. It sounds like you're acknowledging that there are protections in our confidentiality order that would protect against the kind of conduct that your clients are most concerned about. So I'm going to order that you produce the unredacted documents and designate them as confidential. And I'm sure Mr. Toddy will advise his client not to share them for fear of sanctions.
Of course, Your Honor.
All right. So I think we've taken care of number 3.
This last category, well, category number 4, we're going to come back to category number 1. We're going to take category 4 real quick here. The issue here is that we're asking for documents related to capital contributions made to PFP. Defendants claim that they have produced everything that they have. That may or may not be true. We don't have any indication that they are lying to us on this particular category of document, but given their track record in the past, we are concerned that as we move forward, we're going to find out that there are, in fact, documents that they are withholding. It is much easier for us as counsel for Dr. McCord to obtain those documents and to seek recovery for our fees in having to file motions on those documents if there is actually an order requiring defendants to produce those documents. If the defendants have truly produced everything they have on this issue, then the order doesn't harm them in any way. If they have not produced everything and we don't have an order requiring them to produce it, then we go through a whole rigmarole again of filing a motion to compel or whatever. And so that's why we would like the court to actually enter an order on this category of documents and all the categories of documents we're talking about today, actually, requiring defendants to produce them. If they've already produced them, no harm. There's no skin off their nose if they are required to produce documents in an order that they've already produced.
I think this is a distinction without a difference because the representation has been made. Defendants have represented that they have produced this to the court. If that's not a true representation, I have the basis to act on the basis of that false, incorrect representation. If it causes you to have to file additional motions or take additional time to track that down and point it out to me, there are measures I can take to reimburse and adjust those costs. I don't think that we need a formal order on this. They're aware of the defendants are aware of their discovery obligations. They've represented that they've satisfied them. So if we have to come back and there's evidence that they didn't, then everybody knows where they stand. And I will be no less willing to act simply because there's not a formal order in place.
Understood, Your Honor. Let's go to the due to, due from ledger then. That's the first category that we enumerate in our motion for reconsideration and that we discussed in our initial motion to compel. So this due to, due from ledger, defendants contend that they have produced it. The testimony of defendant Philip Miles makes clear that that is not the case. We do not have this ledger. It is true that on February 14th, 2020, the same day that defendants responded to our motion for reconsideration, they produced a 2-page document that purports to show some of the amounts due to and due from CurePoint. Unfortunately, that document's been marked confidential, and because we are in a, I can see up on the top left-hand corner of my screen here, we're public, in theory at least. I don't know how many people are hanging out on the court's YouTube channel actually streaming this, but
You'd be surprised. I might get 10 or 15 sometimes.
really. In any event, the document is marked confidential, so I'm not going to share it on the screen. But I would like to just describe it in general terms. It is a PDF document that is expressly limited in the scope of time that it covers, from January 1, 2019 to October 15th, 2019. Again, we've got that October 2019 date where defendants are cutting things off again. It also has a summary. This two-page document has a summary purporting to show amounts due to and due from various entities that Mr. Miles owns or controls. But that summary plainly includes data that is not contained in the remainder of the document. So there's this summary and there's this column of transactions. The summary clearly reflects data that are not contained in the columns that are also on this two-page document. There are no tabs on this document. It is a PDF document. It is not an Excel spreadsheet. So when you compare that document with what Mr. Miles actually described in his deposition, the produced document clearly is not the ledger that Mr. Miles was talking about. And I'm gonna share my screen here real quick, if that's okay.
Yes.
We'll look at some testimony here. Let's see here. So that is. So this is from page 38 of Mr. Miles' deposition, where he testifies there from line 10 to line 11. He says that this ledger allows us to know to the penny which entity owes what other entity. I don't want to mislead you in the answer. There is a ledger, and if zero holding owes zero res 432, then he interrupts himself, and then Mr. Barton asked him, where is that ledger? He said, that'd be located on my Dropbox or computer. In other words, it's very easy for him to access this document. Then he testified, Mr. Miles testified, that the ledger is an Excel spreadsheet. So starting on line 14, it says it's on Excel, and it might have 100 entries. And then in Excel, you go, what is the net for that entity? Perhaps zero holding. Zero holding, by the way, is an entity that Mr. Miles owns and controls. It apparently is the owner of some zero res franchises. Has nothing to do with CurePoint, which is a cancer treatment clinic in Dublin, Georgia. So it says perhaps there's an entry for zero holding for this entity, perhaps PFP, and it's summed. So it's not a separate ledger. It's all in one comprehensive ledger, and it's summed to the various entities. Mr. Barton confirms with him. So it's one comprehensive document. He responds, that's correct. Mr. Miles then testified that this ledger has been in existence for many years. Mr. Barton asked him, how long has that ledger been in existence? Because I would say for at least 2 to 3 years. This deposition was taken in 2019. Line 11, did you start it after January 2018? Response, no. So in other words, it's been in existence since before this lawsuit was filed. It says, when was it started? This is response, 2016 or 2017. Then Mr. Barton asked him later in the deposition, so does this show comprehensively all of the amounts due to or from CurePoint? He responds, does not include physician financial partners. I'd have to look at it. Support if MEC. MEC is also an entity that Mr. Miles owns and controls. Is inclusive or not inclusive of zero holding? My assumption is it is, but I'd have to check that. Mr. Barton asks, what would you look at to check that? His response, if there's any other tabs, in other words, tabs on the spreadsheet, the sheet, or I would look back at these individual entities. In other words, We'll stop there. In other words, this ledger that Mr. Miles describes, I'll go ahead. This ledger that Mr. Miles describes is obviously not what Mr. Miles is talking about. The ledger that he was describing in his deposition is comprehensive, a single document spanning time from before the lawsuit was filed through the present. It has tabs because it's a spreadsheet, not a PDF document. They have not produced that ledger. We are entitled to the ledger itself. Apparently what is going on here is defendants are taking the raw data, the raw financial data that are kept in spreadsheets, and as we'll discuss later, QuickBooks files, and are creating documents that they are then producing in this case. We don't want documents that defendants have created for production. We don't want documents that defendants may use as exhibits at trial. We don't want that. What we want is the underlying data. We want the spreadsheet itself. That's what we asked for in our motion to compel. That's what defendants claim to have produced to the court, and that's what we're entitled to receive. We want the ledger. So that's the basis for our motion for reconsideration on that ledger.
All right, so Mr. Raley, is Mr. Toddy correct that you did not produce the Excel document with all of the transactions and the underlying data that support those transactions?
No, the information that has been provided, and Mr. Toddy alluded to it, it is in PDF format.
It is in PDF form, so that's what I'm asking.
Correct.
So you produced a PDF.
Correct.
Which is a sort of a snapshot of certain categories of certain categories of data that's on the spreadsheet, but you did not produce it in its native format.
We did not produce it in its native form. No.
All right, so tell me why you can't produce it in its native format, or why you shouldn't produce it in its native format.
We can, Judge, if it will help clear things up. And I, reviewing some of the issues here, I just think that there's some confusion about what the due to, due from ledger is, because the plaintiff has the due to, due from ledger. Now, and if I can share my screen for a minute, I can demonstrate. I have redacted some of the entries because well, actually that one's not redacted. Hold on. Yeah. So here's an example, Judge. This is the first page. Well, here, this is a summary page of what was produced. And again, these are, this document here, for example, this is simply the Excel spreadsheet saved in a PDF format. It's nothing nefarious was done to the document. I can go to Excel right now, whatever's up on my screen, and hit, save as, and save it as a PDF document. So it takes a picture of that particular page. So this is the document that was produced. I want to say this was produced way back in 2019. Yeah, somewhere after the close of 2018. And
I will tell you, Mr. Raley, this is a subject that has come up in many a discovery dispute that I've had. And I recognize that, different judges have different views about native format versus PDF capturing. And sometimes it's easier to just simply capture a PDF and make sure that everybody has the same, the
right,
same slice at the same point in time. But I have found generally that it generates suspicion in the other side anytime they know there's a native format and it's not produced in a native format that can be searchable and reformatable and reorganizable. We deal with this in, in audit trails and
right,
and other financial records where they think, well, somebody's altering something, or somebody's put something in here that shouldn't be, or somebody's excised something out. I think the best course of action, and you say there may be some misunderstandings, and it sounds like if Mr. Toddy if he gets the native format, he can look at it and make and assure that he has all the information that he needs, and it will eliminate any further questions about this. So if you can produce it, let's produce it.
Okay, understood, Your Honor. And I think, just so it is clear, because it's been alleged, in the filings here today that there was some sort of misrepresentation made to the court about what was produced.
You don't have to defend against. You don't even have to defend against that.
Okay.
My sole purpose is to untie the knot, eliminate the blockage, and facilitate the free flow of information.
We can do that, Your Honor.
All right. So I think that takes care of at least the first 4 categories of documents that you were concerned about, Mr. Toddy. There are some others.
Yeah, so that takes care of the motion for reconsideration, Your Honor. Now we can move on to the second motion to compel.
All right.
With regard to that motion, we're seeking the production of CurePoint's financial records in native format. Given the trouble that we've had so far, and given the court's clear rulings repeatedly that Dr. McCord is entitled to CurePoint's financial records, we don't think that there's any serious contention or any colorable contention that Dr. McCord is not entitled to CurePoint's financial records. So defendant Philip Miles has a son named Michael who does accounting work for CurePoint. Michael Miles, we took his deposition. He testified of the existence of several categories of financial records that he maintains for CurePoint that have not been produced in this case. He testified that he maintains CurePoint's financial information using QuickBooks online. We can, I will share screen here. There we go. So he testified that he maintains QuickBooks accounts. You can see there on line 7. He says in line 10 that it's QuickBooks Online. And 14 and 15, line 14 and 15, he confirms that it's financial reports and documents relating to CurePoint. He also testified that he makes those entries on CurePoint QuickBooks. He's been making them since line 10 there, since before January 2018. He's continuing, at least at the time of his deposition, he was continuing to make those entries. He says that defendant Miles, there at the bottom, line 16, 17, 18, and 19, he makes clear that his father, defendant Philip Miles, has access to those QuickBook records, so they could be produced easily in this case. Mr. Barton asked him if it's a general ledger, does it generate financial reports? Then on line 2 of page 26, he responds and says it's all financial reports. It's from balance sheet, income statement, payable reports, receivable reports, everything that you need under accounting. We don't have those documents. Those documents have not been produced, although they were requested at the very outset of this case. Our very first set of discovery requests to the defendants asked them to produce all of the financial records of CurePoint. Mr. Barton then asked him, this is on page 26, line 12, are those various financial statements that you mentioned, are they done for a particular period, like monthly, quarterly, yearly? How are they broken down? He said they're done monthly. And Mr. Barton asks him, has that been true since at least January of 2018? Mike and Miles respond, yes. So there's monthly reports since January of 2018. We do not have those. We do not have those reports. We may have a smattering of those, but we don't have all of them. Then on page 56, he asks on line 18, so monthly financials, financial performance, that sort of thing. Do you send her, meaning defendant Jamila Databoy, any sort of monthly, quarterly, periodic reports? His response, those are sent to Philip. So he sends these reports to his father. His father, again, has these reports and has access to them and can produce them. Stop sharing here. Mr. Miles testified in his deposition that he receives these reports and he keeps these reports. We are entitled to the production of these CurePoint QuickBook records in their native format. And we are also entitled to the production of these monthly reports that are generated and delivered to defendant Miles for CurePoint. They clearly are responsive, they clearly are relevant, and we're entitled to the production of those documents. And again, in their native format. We don't want documents created for the production. We want the native documents themselves.
All right, Mr. Raley, have all of these documents been produced?
No, Your Honor. These documents, and again, these are the subject of the second motion to compel that is, this is the first time that has actually come before the court. And, this issue was teed up about the time that COVID started. And then we had those delays, and then we had a change in judge as well in the case. So yeah, this motion, actually the motion for reconsideration and the motion to compel, that's why they are so old, is they were back then. And my response, Judge, I think, I'm not sure how clear it was coming out of the briefing. I don't have an objection to providing the balance sheets, the income statements, et cetera. That's fine. We'll designate those confidential. My objection and our objection has been one of the similar to the issue I raised earlier with regard to timing. So earlier on in the case, when it was a February 2018 pleading, in the fall of 2018, Mr. Toddy acknowledged some of these records were produced. They do have some of these records back from that 2018 period. When the complaint was amended to get to in October of 2019, we have not provided updated records through October of 2019. One of the hurdles there is when I attempted to communicate our position, as I stated to you earlier, that our understanding was that the record on the discovery side, the records up through October 2019 were discoverable. The responses that I received were, we're entitled to all documents, all financial records, without limitation in time, without limitation in scope. If it's a CurePoint financial record, we get it, and we get it through today or whenever. And so that's been the issue with the production of those financial records. What I was certainly prepared to come in here today and say to Your Honor is, we don't have any problem providing those records. And if native format is what we're doing, that's fine. In native format, and I was going to say through October 2019, which is the date of the operative pleading. Happy to update, what is provided into 2018. Now, the question I think is, with regard to Your Honor's statement earlier today, is if the nature of the complaint as interpreted by the court is broader than claims or actions taken prior to October 2019, and you need us to provide records more current than that, then we will provide records more current than that. I don't think there's a dispute here with regard to the substance of those reports that are prepared and then sent over to CurePoint on a I think it's monthly or semi-monthly basis. We don't have an objection providing those records. Our question was just one of for what period of time do we have to provide those? And as I indicated earlier, our reading of the complaint up through October was that it now covered things that had happened up through October of 2019. If we need to go beyond that and provide those reports, we can. You know, again, Judge, the other thing that I would throw out for the court's consideration is I do think that there's a crossing of the wires in terms of the claim to that all financial records are relevant to the case. I mean, I've, you know, there cases are legion in Georgia that kind of a request is too broad. And it is also too broad when you're simply looking to see whether something occurred. You know, there are cases that I pulled. I won't pull the screen share up right now to do it, but there are cases that, you know, simply said you can't go fishing here in a conversion setting to see if somebody converted something. You have to have a basis for that request, and that's all that, you know, the position that we have taken here. I want to give them all the financial records that they're entitled to, but a request for quote all financial records, you know, is something under Georgia law that I think is overly broad and not justified under the facts of this case.
All right, I understand your concerns. I think these records are reasonably calculated to lead to discoverable evidence. They may not be admissible. They may ultimately not wind up pertaining to any issue that will go to trial and may never see the light of day in a courtroom or otherwise. But I think they're discoverable, and I think they're discoverable up to the present. So I'm going to direct you to produce them in native format and up to the present time. And, you know, it's been over a year. And, you know, I'm not suggesting that you have to keep going back every month and resupplementing and resupplementing and resupplementing. But, you know, there's a duty to seasonably supplement. And, you know, as we go along, if we get into an issue where Mr. Toddy wants a further supplementation and we think it's too much in time or it's too much of a burden, we can talk about that. But let's at least for now get it up to the present time.
Understood, Your Honor.
All right. So let's go to the next one, Mr. Toddy.
That is actually all of it for today, Your Honor. We filed a motion to compel, I think it was earlier this week, but that one's not ripe yet for consideration. We'll address that later.
All right. So once that one is fully briefed, we'll get that one scheduled. We won't wait a year. We won't wait a year this time. We'll get that one. We'll get that one scheduled in a timely manner. Now everybody is up to speed, and y'all are very conversant with Zoom and showing me documents that are helpful for me to see. So I think this was a productive hearing. It sounds like y'all are working together reasonably well, although you have some differences of opinion. That's what I'm here for. I'd like to make it easier on both sides. If you're butting heads on a discovery issue that's coming up the works, don't file a brief, don't file a motion, don't attach a bunch of exhibits. Put your PowerPoint deck together and send Mr. Townsend an email and say, we got a discovery issue. We'd like to get on Zoom and see if we can resolve it. And we can walk through these issues just like we walked through these issues today and get you going on your way. I still want y'all to talk first and see if you can resolve it. I still want the meet and confer. But if you talk through it and you can't get there, then I'm happy at any point in time. We'll set a date and we'll walk through it and keep you guys moving and going forward. All right.
Judge, if I could raise one, this isn't a dispute. I think it's just something that is uncertain with regard to discovery in this case. Judge Bonner, I believe her ruling back in November, subsequent to the ruling in November, we submitted a joint, basically extension of the discovery deadline that was tied to the receipt of documents in her order. And In that November order, as you may recall, what she addressed and the documents that I believe she was referring to that would need to be produced were those third party, were the subject of third party motions to quash that we had filed. They were bank records. I can't remember. I think First Liberty was involved in that motion as well. But basically, the judge's order on discovery said once those documents are received, I believe it was 90 days, and it was an order that was submitted by the parties. Since that time, we've had. I mean, Mr. Toddy served a series of bank subpoenas recently, and I reached out and said, "Wait, discovery open. I thought it was closed. I thought we finished this a long time ago." And so I would like to at least raise that today, whatever the resolution is, and I just want it to be clear what the discovery is, whether discovery is open, not open, so that if we want to undertake in anything else, then we can do it without potentially having to come back to you and say, Judge, tell us what you think about the discovery period.
So let's talk about the discovery period. Do both sides want to conduct further discovery? Because, I think we're in a place where there are additional documents to be produced, and those documents may lead folks in some different or new directions. So my own view is that it would probably be advisable to put in a new discovery order and some limited discovery schedule tied to concrete dates so that we can get it done and not tie contingent to some event happening in the future.
Right.
So if y'all can get together and agree on a schedule for wrapping that up, then submit it, and any reasonable time period y'all can agree to, I will sign off on it. If you can't agree, then let's have a conference and I'll impose something that probably neither one of you will like very much.
Fair enough, Your Honor.
All right.
We will have a discussion, Your Honor. Thank you.
All right. Any other business that we need to take care of on this beautiful Friday afternoon?
Nothing for today, Your Honor.
All right. Good to see everybody. Everybody have a great weekend.